All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for You Can Help Adoption Succeed by Spotting Issues Early. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you're registered, you're going to receive a copy of the recording and the materials from Zoom within about 24 hours or so. We will also be posting it on our YouTube channel, and I will also be updating the website that I have with all the recent and upcoming trainings for this series. So I'm going to drop the email in the chat just in case if you need any of these resources. This training was approved by the Florida Bar for 2 general CLE credits, for 2 adoption law certification credits, and 2 juvenile law certification credits. I'll announce that CLE code towards the end of the webinar. I will also drop it in the chat. It will also be included in that email from Zoom. And in the YouTube description, if you expand it, you can also find the CLE code and the link to the materials as well. If you need a certificate of completion or attendance after the webinar, feel free to email me. I'll probably get to those tomorrow morning. So if for whatever reason I miss out on it, feel free to email me again because it sometimes happens. So uh, and also, let's see what else I have pending questions and answers. If you do have questions during the webinar, please use the Q&A feature. We have a lot of materials to get through, so we will try to address any pending questions towards the end if time permits. If time doesn't allow for us to answer all the questions, then I'll make sure that our speakers have access to these questions and we'll share the answers with everybody afterwards. So let's see what else. This training is being co-hosted by the Public Interest Law section of the Florida Bar, so or PILS. If you're not familiar with PILS, I will drop the link for the PILS website and social media accounts into the chat so you can familiarize yourself with them. One of the most active work groups or committees that we have at PILS is the Children's Rights Committee, led by the great Robin Rosenberg. So with that said, I'm going to pass it over to you, Robin, so you can introduce yourself and our speakers.
Thank you, Jorge. Christine, can you do the next slide, please? Welcome, everybody. Very excited that you're here with us for this super important topic. So many young people get adopted from care. Others languish that need to be adopted, and far too many come back into the system or end up homeless when the adoptions really didn't work out well. So the more we can do upfront to address issues and posture the situation for the best outcomes with adoption, the better off everyone is. So I'm very excited to be joined today by my colleague Christine Smith and our friend Susan Levin, who are the true experts in this arena and will be conducting today's webinar. I do want to give you a little bit of background information. If you could do the next slide, please, Christine. So this webinar is part of an ongoing series of trainings, which is part of our mission at Florida's Children First, which is to train and support the attorneys that are working in the child welfare system to improve outcomes for the young people that are served. But training for attorneys, judges, and everyone that touches the system. So one of the other ways that we support attorneys is through the Florida Dependency Law Center. So if you're an attorney or a judge, you are invited to join the Dependency Law Center. It is a free resource. There's a bunch of different things on that resource. We use the listserv for registered users to keep people updated on upcoming events and what's changed in the law. But there's also a way, if you're looking for a specific training on a topic, or you just need more CLEs before your time is up or your certification, you can search for the CLEs that are available by topic. You can look at upcoming conferences. And one of the things that we are committed to doing is to enhancing, improving a toolkit of, I call them pocket memos, but non-specific memos and briefs on topics of interest that when you come across a topic that's new to you, you don't have to start from scratch. And so Christine is going to be working on that endeavor for us at the Dependency Law Center. So this is part of our overarching goal at Florida's Children First to support and improve outcomes for young people. So the two upcoming trainings are next month. I will be doing a training on independent living benefits. So what they are and how you get them, and how a single decision can radically alter the benefits that are available to a young person. So I hope you will join me on August 19th. And then our September training we're every third Wednesday, is Erica Herring, and she'll be talking about early intervention and early identification and interventions for childhood disabilities. So with all of that, I will turn it over to Christine to get you all started, I think, with poll number 1.
Yes, so good afternoon, everybody. We always start the afternoon trainings with who do we have here so that we can always speak to our audience and continually make trainings that are relevant and are of interest. And we usually bookend the trainings with a poll that says, what do you want to have a training on? We are always looking for what is of interest to the audience, and also we can grab speakers like we did today. We are child welfare attorneys. We represent kids in the dependency system, and my colleague Susan Levin is a private attorney, and she does all things adoption. So she's on the private side, and if we need to, we can always grab speakers outside of Florida Children's First, like we did today. So we would like to know who we have here so we can sort of tailor our trainings and make sure that we're answering questions and topics of interest from more than just one side. And Jorge's running the poll and watching when we have an appropriate number of responses, then he can tell us who we have today.
All right, so we're over 100 responses, about 70% participated. So I'm going to go ahead and end it in 3, 2, 1, and I will share the results. Here you go. Let me know if you see them.
Yes, I see them. So it looks like more than half of us are attorneys, and kind of a scattered, we have some case management and CBC subcontractors, which I'm happy to have, and our friends over at the Guardian Ad Litem and CLS is only coming in, DCF staff 1%. So welcome, everybody. I'm glad that this is a topic of interest to you. As Robin said, we're always trying to see how we can do things better. I think all of us in child welfare have that same desire to how do we catch things on the prevention side rather than mandating things when they don't work out on the tail end. So that's really what this training hopes to accomplish, is that to get everybody thinking about how we can work together. I know in my practice, I represent kids in foster care and in non-relative care, just out of home care, really. And the overarching question for myself is how can I do it better? And particularly when we are working on a case that does go to adoption, there seems to me at least to be a silo between the handoff between dependency, TPR, and then eventually to the private adoption attorney. So that is really why I would like to have this topic discussed so that we can all ask ourselves, how can we open that bridge? How can we expand that? So I'll kick it off with a fact pattern. We have Anna, who is 13, and she turns 14 in November. She's been in licensed foster care since she was age 7, and she's been matched with a pre-adoptive family, and things are close to finalization. Anna's pre-adoptive mom would like to finalize the adoption before Mother's Day. So we know from the fact pattern that we're probably maybe in the early part of the year before May, and that adoptive mom wants to celebrate the finalization with Mother's Day and adoption together, and that Anna turns 14 in November. So if you're part of Anna's care team, what sort of analysis should you be doing to make sure that the family and Anna, depending on who you are, right? So if you're advising, if you're maybe part of, the case management team, you might be advising the adoptive parents of some of the benefits. If you're part of the independent living, that would be your role as well. If you're a guardian or attorney ad litem, then you'd be advising Anna herself. And over the age of 12, we know that kids have to consent to their adoption. So although, this is post TPR case, things are moving towards adoption. Everybody gets really excited, and it is, the finish line for kids in care. And especially if a kid has been in care since age 7, that's a really exciting time for both the child and the adoptive family. And you have this emotional request to have things finalized before Mother's Day. But what would you want to take into consideration if you're part of Anna's care team? And I worded it that way on purpose because I know we have an audience that is a wide audience, and in my role as an attorney ad litem, I'm only advising Anna, right? So you might be in the position where you're more on the team, and you're just bringing issues to the table. You're not necessarily advising anyone in particular, but you want the issue to be presented maybe in a staffing or in court. So if you're part of that care team, what would you want to consider? Would you want to consider that Anna could lose extended foster care benefits if she were adopted before 13? Advise Anna that she may want to wait until after 14 to preserve the post-secondary educational support services, or she will get the benefits no matter what, or I'm not sure.
So I see
Check
answers
in.
coming in. We're close to 50. We're over 50%. So let's give them a few more seconds.
And whenever I'm doing these, if I'm not sure, if people don't answer, they're either checking emails and doing other things while they're listening, or they're not sure, but they don't want to say they're not sure. And that's okay. That's a perfectly acceptable answer, that I'm not sure, because guess what? I always check the independent living chart. So that is that's the hint.
All right, so we're at 60%, so I'm gonna go ahead and close it out. And 3, 2, 1, and ending the poll. Let's share the results.
And so we've got us. Looks like 50% is not sure, and it looks like close to the other, making up close to 50%. We have advised Anna that she may want to wait until after 14 to get PES. She'll get the same benefits no matter what, and then I'm not sure. And I like the I'm not sure answer, because guess what? This is sort of an appetizer to Robin's training next week, because we have changes to our independent living benefits. And my advice to you is to check the chart. That's what I do. Even if I think I know the answer, I go back to the chart and I look at the references, and I take a look at it. I know that on my far left, things are cut off a little bit, but I've yellowed the box that is applicable. So if Anna is about to turn 14, right? If she were to finalize prior to if she were to go ahead and finalize, she can eligible for post-secondary education support adoption after 14. So that's the box that we want to look at. If the child spent at least 6 months in licensed care, of the 12 months immediately preceding the adoption in foster care, she can get PES, PES, if she waits until after age 14. So I would advise Anna that she may want to, I know we want to have our Mother's Day celebration, but you will lose your PES benefits if you finalize prior to your 14th birthday. So I would advise Anna that, hey, that's a benefit that you could get if you hold on the adoption for just a few more months, which is a valuable subsidy. For those that are not familiar, if a child is in child welfare and then they get adopted subsequent to their 14th birthday, they will get a stipend if they are in college, right? Post-secondary benefits. And it's an actual cash amount that they will get, which basically can pay, I think their current benefit amount is a little bit over $1,700. And Robin dropped the link to the chart. I know this is a little hard to it's multiple pages, and I've only yellowed the applicable parts. So if you follow the link, you can get the whole chart, and you'll see that we just recently updated it on the web. On the top bar there's things that changed recently, and I've honed in on the yellow with what is applicable to this fact pattern. So my advice is to always check the independent living chart if you're dealing with a teenager. And so now we have another fact pattern, Philip. Philip is 15 and has been living with his maternal aunt, Chantel, who is in the relative caregiver program. He doesn't know where his father is, and mom was sentenced to 10 years in prison, and the court just entered a termination of parental rights order. Philip's aunt is not sure about whether she wants to adopt him or whether she wants to have the case go permanent guardianship, because she's afraid that it may replace his mom. She recently had a work injury, and she was not able to work full time, so she lost her employee-related insurance. So those are some things that we can glean. We know that Chantel's a relative. She's in the relative caregiver program, so that means she should be getting money per month to take care of Philip. We know that she now is not able to offer any employee-related insurance benefits from her side. So if you're representing Philip or his caregiver, so I've worded this to be wide enough to be what are the issues, not necessarily specific to any one particular category of representation. But if you're representing one or the other, what do you want to consider? What do you want to analyze? And if we could have poll number 3, Jorge. So if we're on Philip's case, are we going to be looking at the guardianship assistance monthly amount, the adoption maintenance subsidy amount, Medicaid benefits, permanency, or all of the above? Give everybody a few more minutes to I feel like this is Jeopardy. Log your answer in, and Jorge can flash us up the results.
We're close to 100. Seems like we have a clear winner here, so I'm gonna go ahead and close out this one in 3, 2, 1, and ending the poll, sharing the results.
Yes, all of the above. That's exactly correct, because we have, and I'll flash up our independent living chart again. I've yellowed out the boxes that are applicable to him, because Philip is 15, so he fits right in between permanent guardianship entered between 14 and 18, and extension of the guardianship assistance program after 18, if opted in after the youth turned 14 and before turned 18. So that and adoption after age 14. So we would be looking at those yellow boxes, and if we kind of compare the two, we have a yes and a yes for a tuition fee exemption. We have a no and a no for guardianship assistance program, adoption subsidy maintenance. Well, under permanent guardianship, you're never going to get an adoption subsidy, because it's not an adoption. So if he's adopted, he gets an adoption subsidy, but not if he goes PG. And so on the PES, we have a yes and a yes. So those are the same. So we're going to look at all of the benefits. And then what would we really want to hone in on is that Philip, if he's in foster care, he should be on Medicaid. And if our caregiver finalizes, she may or may not, and our fact pattern tells us that this particular caregiver does not have employment-related benefits to add Philip to, so Medicaid becomes even more important. And we have a box here that on the permanent guardianship side that says that the guardian must complete an application for Medicaid to continue, and that if he's adopted, Medicaid continues to age 18. So it's looking like, in comparing the benefits, that adoption seems to be a better option for this child, at least from the benefits standpoint and also from a permanency standpoint, right? So always, when you're dealing with teens, look at what the timing, how old they are, and what benefits they would qualify for based on their age and based on the permanency. And that's where you can really make a difference in a child's what their future looks like. So I encourage you to look at that, and I encourage you to attend the training next month. And so we have our last fact pattern. Maria is 17 and was matched with an adoptive family who are U.S. citizens. Maria was born in Honduras and has deferred action pursuant to a special immigrant juvenile visa approval. With recent immigration changes, a work authorization will likely be unavailable, and she will not be eligible for legal permanent residence until after she turns 18. So that's a lot of information. And the basic question is, if she's with an adoptive family who are U.S. citizens, is Maria's immigration status a barrier to her adoption? So Jorge has already flashed up poll number 4. Is Maria's immigration status a barrier? No, and her adoptive parents will be able to apply for Maria to derive citizenship after adoption. Option number 2, yes, because she's Title IV-E ineligible. Or 3, yes, because having a permanent adoptive family will disqualify her from having SIJ status. Or the other one, no, but it will not help her immigration status. Or the last option, I'm not sure. While you're pondering that, I think, as you can see from the answer choices there, that immigration is complicated, and the point of this training is to kind of flesh out that there are issues that you should be thinking about. That doesn't necessarily mean that you have to have all the answers. It just means that you should bring the issue up so that you can seek out the answers from someone who knows the answers if you do not. So you only need to get to issue spot and get an expert involved. All right, Jorge, what do we have for our polling? Okay, so yes, is Maria's immigration status a barrier? No, it is not a barrier, and her adoptive parents will be able to apply for Maria to derive citizenship. So that answer choice number 1 is, unfortunately, it's a depends, right? With foreign-born children, and that's going to be, Susan's has a few slides on that, so I won't drill down to it too much, but when you have a foreign-born child, whether or not they can derive is determinative by a lot of facts. And we know here that Maria is 17, and so unfortunately, she's too old to derive an adoption benefit from her adoptive parents, even if they are U.S. citizens. So that's not the answer choice. And then yes, because she's Title IV-E ineligible. Now, answer choice number 2 is partly right. She is Title IV-E ineligible because she doesn't have a work authorization, and maybe she does, maybe she doesn't have really the trigger point for that is a social security number. Typically it's work authorization, social security number come, coupled together. And if she doesn't have that social, she's Title IV EN eligible. That doesn't mean she can't be adopted. It just means she's not going to get the adoption subsidy. So that number 2 answer choice is partly right. Number 3, the question is it a barrier? And yes, because having a permanent adoptive family will disqualify her from SIJ status. So that is a question that has gone back and forth according to immigration policy, and that I would encourage you to always check the latest memos on the topic, because they change with the wind. It's not law, it's policy memorandums, and it really depends on who's in office and what the latest and greatest policy memorandums say. Right now, it's not, but that's subject to change. So always check with an immigration person before you finalize. And then the last answer choice, no, but it will not help her immigration status. That is the correct answer. So it's not, she can be adopted. However, if her pathway is special immigrant juvenile, it's neutral. The adoption is neutral. It's not going to help her, but it shouldn't harm her either, because her pathway is not going to be derived from the adoption. Sometimes you can derive an immigration benefit from an adoption, but in this fact pattern, she's too old for it to work for her. So it's not going to help her. So if you have a case with a foreign-born child, you should conclude that you need to get an expert involved. You need to get somebody involved that knows. All you need to do is know you have an issue. And particularly if you're working with a family, they need to know they have an issue, and they likely do, because most often if we have an immigrant child, they don't have, at least at the beginning, they don't have Medicaid benefits available to them until they get that SIJ approval. And then once they get the SIJ approval and the subsequent Social Security, they then can be Title IV eligible, even if they are not going to derive the citizenship from the adoptive parent. And I did see a question coming through. It says, so for a child that is younger than 6 years old, would adoption be a path for immigration status? Veronica, that was a question coming in the chat. That's a it depends question, and I won't drill down too much into it because Susan has some slides on that. But what you need to know is that, yes, a younger child may be able to derive. It depends on the status of the adoptive parents, and it depends on the country that they're from, and it depends on the custodial status. So there's a lot of it depends. And Margarita says, if an infant is adoptive and by age 5 the kid is autistic, special needs, will the adoptive parent get an extra stipend? So if we're just talking about a non-immigrant child and the child is age 5 and has special needs, the parent could get an enhanced stipend. It depends on whether or not the child has already been Social Security eligible. And we're going to get into that here pretty soon. Let's see. Let me advance the slide. So we're getting to that, Margarita. You're very timely in your question. So we have on special needs kiddos, and I'll say this. In preparation for my own slides, I went out and Maria Bates is an adoption attorney in Sarasota. She did 2 presentations, Beyond Paper Pushing, and a secondary series on subsidies themselves. So this is not meant to replace those. Her second session on it was a little bit more comprehensive. This is a primer to let you know that there are issues, and and that you can to inform yourself that there are issues with special needs kids. So what you should be asking yourself, and again to the issue spotting, is does the child have any special needs? And if you are on the case, you should be looking at the CBHA, which is the Comprehensive Behavioral Health Analysis. And one of our colleagues, Erica Herring, did a whole presentation on CBHAs. So if you want to know more on what the CBHA should have and how to use it, you can go watch that training. But it will usually detail if there is a diagnosis of the child. More often than not, what I see with CBHAs is they're done at the beginning of the case, and you may not have that diagnosis listed, but with children in foster care, they should be repeated every year. So if it's been over a year, if you're looking at the file, looking at the dependency file, and the CBHA is older than a year, ask the judge to order a new one, because there may have been a diagnosis in the time frame. And sometimes you're not always on the case from the very beginning, and you don't have all of the information at your fingertips. So the CBHA should detail it, but if it's older than a year, get a new one. Review the docket for any 5339 forms. That's the form that should be filed if a child is on psychotropic medications. It has to state the reasons why, the dosage, if there's any reasons for the prescription, and it should at least clue you into what the diagnosis is, or if it doesn't state the diagnosis, you can at least Google the medications and do some digging, find out if this child is on psychotropic medications. Then they sure better have a diagnosis, right? We shouldn't be giving kids medication without some sort of a diagnosis. Review the docket for any order authorizing the medical treatment. So this might be more towards physical. So if we have any orders that are authorizing medical treatment, that would be another trigger point for you to say, okay, has that been totally resolved? Is this something that is still ongoing for this child? If it was tubes in the ears, or if it was something like, did this child have brain surgery, or is there something neurological going on? It's another way for us to gather information so that the adoptive parents will be advised of these things. Does the child have an IEP or a 504 plan, and why? Again, we're information gathering. We're teeing it up so that we're not doing things in a vacuum on the dependency side that then the adoption attorney doesn't know about. If the child receiving any therapies, if so, dig deeper to make sure you know the funding source and if it will continue. So if we have a special needs child, are the therapies through APD services? If they are, then then APD services should continue. But if they're not, then consider making that APD application. And does the child get Social Security? So this is a broad sweep of, let's look at the file. Let's make sure that we know what the special need is, what the diagnosis is, and go on information gathering hunt. Because again, you might not have been on the case from day one to present. And I think that's probably more often than not, right? Sometimes I myself get appointed late in the case. And so I will try and glean as much information as I can from the docket. And if I don't have everything, then at least I'm asking questions, because I'm putting the puzzle together and putting the pieces together. I think APD eligibility is really, really key. We don't want to finalize with a kiddo who might be eligible, and let's do that application sooner than later. And if to be eligible, the child must have a developmental disability. So back to autism, because I see autism a lot. Autism is a spectrum, and so sometimes it will qualify for APD and sometimes not. It has to be something that is a substantial handicap. So there we go on the spectrum with autism, depends on what the spectrum is. And if it constitutes a substantial handicap, that's going to be expected to continue indefinitely. With very young children, and I'll skip down to the bottom part of the slide, if children are under 3, they are served by early steps. And so if you're on the border for a kiddo that is about to be adopted, let's say they're 3 and they're almost 4, you may want to wait to finalize an adoption until after they turn 4, get the APD services in place. So that's one less thing to have to get into place after the adoption. So here are the qualifications: intellectual disabilities, severe forms of autism, spina bifida, cerebral palsy. Not always with cerebral palsy, but depends on the disability. Prader-Willi, Down syndrome, and Phelan-McDermid. Individuals between the ages of 3 and 5 that are at high risk for developmental disability. And I did see a few other things in the chat. Does it vary by county because hasn't the APD scores getting higher? It shouldn't vary by county because APD is statewide, and so it shouldn't matter what county you're in. And then we have somebody from the chat saying Tate Brown Raman syndrome is now eligible. I don't. I'm not familiar with that particular disability, but that's good to know. Thanks for that. And here's some of the services that can be important to adoptive families that if we can get them in place. And these are just a few of the ones that I see most often, the most useful. But I've linked the APD website there that has the full range of the services. APD services, it can include, so on one of the previous slides, is the child getting therapies and where is the child getting therapies? Because APD can offer a very large range of different types of therapies. So if you can think about it, and if the kid needs it and you can get them qualified for APD, it's likely that they can get it through APD. Nurse care coordination, which is key. Medical equipment, including consumables. So things that I know for some of the kids on my docket, things like diapers and consumables that diapers themselves get really expensive, and in-home medical care. So that maybe caregivers can work, right? It's a tall order for a caregiver to be able to support a child. And if they have to be the full-time caregiver, it's hard for them to work. So it's really, really important to get those APD services in place if you can before the adoption. And to me, it would be worth delaying the adoption until after that's done. And so here we go on Social Security disability, which is a needs-based eligibility for children. If the child is blind or has a qualifying disability that is marked by a severe functional limitation, then they can qualify perhaps for SSI. It has to very seriously limit the child's activities and be disabling and expected to be there for at least 12 months. Or it must be something that may be fatal. If an application has not been made before you and you suspect the child may qualify, do it before the adoption finalization. We're trying to do the heavy lifting for the adoptive parents, and there's a significant wait list that gets longer with APD and Social Security if the child is not in care. So my advice is to get the application in. And I see that there are some things in a lot of things in the chat. Let's see, I'm trying to catch up. It looks like Robin's doing a great job of answering, but if Jorge can help and you can interrupt me, and if anybody has a question that's gone unanswered. Now we talk about benefits that might layer. Can the child get an SSI and an adoption subsidy? Yes, they can. However, because Social Security disability SSI is needs based, then they can. The need is considered, right? The need as far as the monetary need. So when we're looking at an SSI type of benefit, we're looking at the totality of the family resources. We're looking at the adoptive parent's circumstances, and we're looking at the child's SSI benefit level. So in other words, we're not going to add those together. A plus B is not going to be totally additional. You're not going to get the entirety of an adoption subsidy and the entirety of the SSI benefit. One of those would be reduced. So hopefully that answers. I did see one question in the chat, and hopefully if I didn't get to it, I'll get to it on this slide, because this is the Social Security survivor benefit. So this is the case when a child is receiving a benefit tied to their bio parent. So this gets a little bit, some analysis going on in here, because even though the benefit might be coming from a bio parent or even a bio grandparent, the adoption of the child that is already entitled to the benefits, it doesn't terminate the child's benefits. And the rule applies regardless of the adoptive parent's income. So we're not looking at the resources of the adoptive parents here. We're looking at the entitlement from the child. And if one of the parents' child's died, they will continue to receive the monthly payment based on that parent's work history, or sometimes it's the grandparent if the grandparent already had custody of the child. So can the child get the survivor benefit and the adoption subsidy? Yes, they can. The benefit, the death benefit, is not cut off, even though they're getting new parents, which that seems to run counterintuitive, right? Because when you terminate parental rights, they're no longer the child of that parent. But if you think about it, it does make sense, because when a parent dies, there is no termination of parental rights as to that parent. They died, right? So then that begs the question, well, what about if it's a disabled parent? What if it's a disabled parent that then becomes, they then are TPR'd? If a child receives the dependent benefits based on the Social Security record of the living, retired, or disabled biological parents, those should not terminate upon adoption. And I've linked the POMS, the SSA policy manual, to that. However, on my next slide, we have an example here. Bryce, age 9, was adjudicated dependent due to the drug use of his mother and placed with his grandmother. The father receives Social Security disability and is unable to work. His grandmother is retired and living on Social Security benefits. And if what is possible for grandma to obtain if the child is TPR'd as to his parents and is adopted by grandma? So we know here that Bryce's father is disabled, and the survivor benefit, if mom died. So, right, if mom was placed with mom, if it was placed with grandma and mom died, would he continue to receive the mother's benefit? Yes, because she died, she didn't get TPR'd. And would grandma still continue to get her Social Security retirement benefits? Yes, she would. Would she be eligible for an adoption maintenance subsidy? Yes, she would. The only one that I have a caution on here, and I reached out to verify this information. And the POM, the Social Security benefit manual that I had linked on the prior slide says that you can, but I couldn't verify that with a particular case. So if you do have this case where the benefits are based on a biological parent's disability and then the child, so this would be where Bryce's father is getting a disability payment and Bryce is getting it too based on the derivative, and then dad is TPR'd, would that benefit flow through to grandma in the adoption? And the POM says yes, but I wasn't able to verify that. So use that with caution. And if you do have that fact pattern and you do know the answer, feel free to email me. I'll be happy to get that information disseminated to everybody when we send out the materials. And then here's where we transition, right? So we've been talking about the dependency case and all things that we should consider before we get to the adoption. Now we're ready for the adoption. The adoption case is separate from the dependency case. When you file the adoption, when the adoption attorney files, it's a totally separate case, and therefore the adoptive attorney does not have access to those things. So if you're in the child welfare case, go to the staffings, know who the adoption case managers are, and send them important information. Keep confidentiality in mind, but organize your file with the adoption finalization in mind. And here was something that was an outflow from a conversation with a colleague to get the medical records and the birth records, because if you don't, medical records and hospital records can be purged after 7 years. And if you don't get them timely, then time goes by, right? The medical records could be expunged and destroyed before you can get your hands on them. Here's the citation to the exceptions to confidentiality. So I think there's a lot of times when we have to just read through the statute to make sure that we're not stepping afoul of sharing information, because we're gathering all this information, but who can we share it with? We can share it with persons with whom the department is seeking to place the child, or the current placement, including foster parents with an approved home study. We can share it with the designee of a licensed child care agency. We can share it with approved relatives or non-relative with whom the child is placed. So keep that in mind. The relative or non-relative has to have placement in order to share some of that confidential information. The pre-adoptive parents for whom a favorable preliminary adoptive home study has been conducted. So it's not all pre-adoptive parents. They have to have a preliminary favorable adoptive home study. Adoptive parents or an adoption entity acting on behalf of the pre-adoptive parents or adoptive parents. So those are the categories of folks that you can share the information with. And there's your citation. So when we're transitioning the case from dependency to adoption, these are some of the documents that already exist in the dependency court file, and it's important to have those on the ready. And if they don't exist, we need to make sure that they get completed so that we don't then cause additional delays. The UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act, that's going to lay out all the placements for the child. So that's typically filed with the termination of parental rights petition. So you should be able to retrieve it and get it ready. If it needs to be supplemented, it should show all of the child's placements. So if there's a lag between when the UCCJEA was filed in the TPR and maybe a year has gone by and the child's changed placements, you might want to ask for the child's face sheet, which should show all the placements, that you can kind of couple the old UCCJEA together and the face sheet, and then you'll have an up-to-date list of everywhere that the child has been. Make sure that you have the ICWA form on the ready, because that has to be filed in the adoption. And if you do have The ICWA is the Indian Child Welfare Act. That should have already been dealt with in the dependency, but who knows? Maybe somebody missed something along the way. It's another time for us. That is a document that has to be filed in the adoption. So we want to make sure we have it teed up and ready to go. Termination of parental rights order. And make sure that the appellate time has run. I've never seen one finalize before the appellate time has run, but stranger things may have happened if we're rushing. We want to look at and make sure that if there's any home studies that were already in the file, maybe the child is with foster care parents and there was already a home study on those parents. We'll want to dig that out and take a look at it, see how old it is, and who was it done on, and has the household makeup changed. Putative father registry search. My colleague Susan Levin answered this for me on another case that I had recently. In my head, I'm like, if I know who the father is, and I have the father on the birth certificate, and he's TPR'd, why do I need a putative father registry? The answer is, even if you know who the father is or was, like he was the legal father and he was TPR, we still have to have the putative father registry search as part of the adoption, which to me sounds kind of contra to common sense. If I know who the father was and he was TPR'd, why do I have to have it? You just do, because it's statutory. And then we will want to review the marital status of the foster parents. I had one finalized last year, and she was a non-relative caregiver. She had been divorced, and she didn't have a copy of her final judgment to prove that she was divorced. So we had to go digging for it, and it was an older final judgment. So better to know all the requirements and get those chugging along so that you don't have delays when everything else is teed up. That may be the only thing you're waiting on. Review home study for any potential problems. Maybe there was a teenager in the house that aged out, became an adult, and then got into trouble, and now there's somebody in the house with a criminal history. We want to make sure that that we address those and we know about those. Review any incident reports. You should know about these things if you've been on the case for any length of time, but maybe you're a newcomer to the case. And we want to make sure that you know about those abuse reports so that you can anticipate the problems that you might have with a renewed home study and with your placement. Review any potential pitfalls and bring it to the attention of the dependency judge if necessary. So these are all things that we can do before it gets to the adoption attorney's hands so that it's seamless and smooth. And we have poll number 5 up here for our question, just to wake everybody up. A home study must be repeated if it's over 1 year old. Is that true, false, or does it depend? Or maybe you have no idea.
We have about 85 answers in. That's more than 50%. Let's give everybody a few more seconds. I'm one of the no idea ones, but I can't answer because I'm the host. But, that will count as one of those. So let's go ahead and end it in 3, 2, 1, ending the poll and sharing the results.
So a home study must be repeated if it's over 1 year old. The lawyer's favorite answer is always it depends. So I'll flash up the next screen and you'll see why it depends. Oops, I went too fast. Okay, so we had a 2024 legislative change for home studies. Robin always does a really good job on what changed, and I actually went back to her 2024 legislative change materials to get this information and kind of line it up for you. So prior to 2024, a favorable preliminary adoptive home study expired after 1 year. So everybody that said true, you need to perk your ears up and know that we had some legislative changes, and that after 2024, the answer is it depends, because if the child was placed before the termination of parental rights, and the updated placement or licensing home study may serve as the adoptive home study. This was a push to eliminate duplicative home studies for many foster and pre-adoptive families. So in other words, if you have a child that's been in the same placement, we don't have to necessarily do a whole new home study. The lead care agency, they can complete a preparation process that kind of supplements, if you will, the home study, rather than repeating an entire home study. So that's something that you should be aware of. The prior law commissioned updates to the home studies solely because the prior study had aged out. So if it's over 1 year old, under the old law, yes, it always had to be repeated. But the CBCs now may document that prior approval remains valid, and that the required safety checks and household information is current. So if you've had updates, if things have changed, then yes, you'll have to redo the home study. But if the household has stayed the same, then you can rely on the CBCs to supplement it, and it reduces delays and expenses. And then sometimes hearings were delayed, finalizations were delayed to enable that home study to be completed. And so therefore, we can supplement instead of replacing. So it's faster permanency. And just like everything in the law, there's a pro and con to everything. And so here's my big warning at the bottom. Since the file review can replace the child study, I'm sorry, we were talking about home studies here. Now we're shifting gears and talking about the child study. But as part of that legislative change, the child study itself is not always mandatory. And the file review is sufficient for in-place adoptions. So actually, I kind of, that was my poll number 6. I kind of gave away the answer already. A child study is always required, true or false. We can skip over that poll. It's false, because we had a Florida admin code change that file review is sufficient for in-place adoptions. So the case manager or the adoption counselor must evaluate every child's current placement, the projected needs, and document and review all the information available. But a separate written child study is only required to aid in identifying a pre-adoptive placement. So if we have a kid who doesn't have an identified placement, and the current caregiver has not applied to adopt, and that's when we're going to need the home or the child study. So the last slide was on home studies. This slide is on child studies. So if we're not doing child studies on every single child because they're in place, then that means that documenting the file and reviewing the file is now more important than ever. So, and we always want to make sure that things, and from the attorney standpoint, and I go back to our first poll, that probably 57% of us that are doing this training are attorneys. We're looking at the docket. So when we're referred to the file, we're usually looking at the court file, right? And if you're on the social welfare side, if you're on the CBC side, you're looking at the case file. Your case file is different than the docket case file, and so we want to make sure that we marry those together, the docket and the CBC file, to make sure that it's complete and that we have everything. And so This actually, the law changed in 2025 here on this one. So the previous slide, we had a law change in 2024 to the home studies, and now this change just went into effect last June. So we're a little bit over a year now, but I consider it still new. The law doesn't change rapidly, and when we do have new, sometimes we have to remind ourselves what those changes are. And we also want to review family connections. And if it's not, so often what I see is that child is visiting a sibling, or child is visiting grandma, or child has access to particular people. But then when the adoption is done, maybe the adoption attorney doesn't know that that there are current orders in place. And if it's happening, but it's not been reduced to an order, my advice is to get it ordered in writing and pass that order along to the adoption attorney so that they can include it in the adoption itself. So who's the child currently speaking to or visiting? Make sure that it's documented in an order. And part of the criteria for choosing adoptive families are their willingness to foster those post communication contacts. So we want to document what's happening so that it can pass along with the child, right? Because those of us, when the lights go out on the case, it's not going to be good enough for somebody to say, well, it was happening and we just didn't, it didn't follow the child. So we want to make sure that if it's happening, we want it in an order, we want it documented, and that is to establish and promote the child's relationship with her siblings when appropriate, and also so that it can be in the post-adoption communication contact, which is our Florida Administrative Code. Those two factors are in the Black Letter Law and the Florida Administrative Code. So with that, I will turn it over to Susan because I've already taken up probably more of my speaker time than I should have, and I'm pinching her for time. So again, she's probably not going to have time so much for popping in with the questions, but we're happy to answer them as it ends if we have time, or you can always email us.
Thanks, Christine. Can everyone hear me?
Yes.
So it's my pleasure to be here and to at least virtually meet everyone. And as Christine said, my time's a little bit pinched. So I'm going to pivot a little bit and try to give you the highlights of what I hope to convey to you regarding being an attorney in private practice who's handed a case to finalize the adoption. Now, the reason that I have the Raiders of the Lost Ark theme and motive here is because, to me, this subsidy and enhanced subsidy world is like a lost planet. I don't know where to begin. I don't know what all the terms mean. I don't even know where I should start looking. And yet I have been given this responsibility to finalize a case for a child who's coming out of the dependency system. So, Robin, you can go ahead and, Christine, you can go ahead and do the next slide. Thanks. So as a broad overview, you're going to be looking at Florida statutes, Florida Administrative Code, the operating procedures of the Department of Children and Families, internal memos, policies of the 16 different CBCs, and a little bit of case law. You can go to the next slide. Now, actually go back one. When you are working with these statutes and administrative codes, the cold hard truth is the only way to understand it is to go through it. You can't go around it. You can't go underneath it. You're going to have to pull out the statutes, pull out the regs, and slowly go one by one because the answers are all in there. It's just not so easy to decipher. The important thing to come over with today is to know that there are particular benefits that are available for the child and for the adoptive family who is finalizing the adoption. And a lot of what is on this list in my treasure chest are what are the possible benefits that are on the table for a child who is being adopted out of the child welfare system. So we know there's the maintenance subsidy, which starts, at $5,000 a year and can be negotiated up from there. We know that there are enhanced subsidies that you can ask for if the child's needs are greater than standard needs. We know that there's Medicaid, that there are tuition exemptions and fee exemptions for college. There's a federal tax credit. Sometimes if you are a state employee, firefighter, veteran, you can get a chunk of money from the state for adopting out of the system. It's either $10,000 or I think I just reviewed something. It was up to $25,000. Don't quote me on that. You've got the post-secondary education support that Christine already mentioned. You can actually get a state park pass, and you can, in most jurisdictions, you can get a filing fee exemption. I will tell you, and I know that a bunch of my esteemed colleagues who are listening now, there's a big issue in Broward County where Broward County is making families file the filing fee in all cases that are being finalized from the dependency system. And they are also charging per child. You can go back to per child to do the filing fees. And so there's possibility of some court action happening because if you read in the statute, it specifically states that families adopting through the system are going to be able to have exemptions for some of these things. Now, I'm a big picture person. So the reason that we have these in maintenance subsidies and enhanced subsidies is so that children that are harder to place or who might have special needs will get adopted, and the special needs and the special costs and enhanced monies that are necessary to provide for this child will be available so that money and finances are not a barrier from this child being adopted. There have been studies done where the economics show that even giving subsidies and enhanced subsidies to families makes smart economic sense because it saves the state money by having the children be placed in a home. And at the end of the day, we all know it's better for a child to achieve permanency in a home and with a family. So because I want to really get to the information regarding foreign-born children, I am going to skip to go to the next slide, please. So the roadmap of how this should work in a typical case is that a family should have a memo of agreement to adopt, which can now be signed anytime after TPR. The family should get disclosure. And I have samples of many of these forms on here, not so that we go through each form, but so that if you are someone like me who was handed a packet as the adoption packet, that you would see some of the documents that should be there, that your client should have signed, and that should be signed and might need your attention. The problem with this roadmap is that I have disclosure listed as number 2. You cannot know how to negotiate a subsidy for a child being adopted from the system if you don't have all of the pertinent information regarding that child's health, mental health, psychological health, behavioral issues, therapeutic issues, the number of placements they've been in, the difficulties that have been there, the prescription drugs that they're on, the diagnoses that they have. You are operating in the dark. And what happens most of the time is that the families who don't have an attorney ad litem representing the child, or who don't have a private adoption attorney or someone who is taking the case from while it's in the dependency stage into the finalization stage, you don't have anyone who has that knowledge or information. Because as Christine explained, we don't get access to the dependency docket. Once the TPR is entered and it moves on to the adoption stage and it gets handed over to us as the finalizing attorney, we get a very limited amount of information from the agency. And oftentimes what happens is the client has been asked to either adopt the child without a subsidy, B, adopt the child and move to finalization before they have had full disclosure of everything that's going on in the child's life. And they are asked to sign number 6, the adoption assistance agreement, before they have all of the information that they need in order to make the best choice of moving forward with the child for finalization. And this is a system-wide problem. I'm not laying the blame on anyone, but I can tell you that most of the parents that I come on to finalize an adoption for have no idea what those other benefits are that have been left on the table. So I'm going to go through now some tips, and we can advance the slides. I'm not going to go through the process of how this works. Typically, we did it as a quick overview. You can go to the next one. This is the MOA. You need to pay attention to the MOA. Sometimes the form of the MOA is wrong and incorrect and violates statutory or federal law. Skip to the next one. Don't be afraid to cross things out. This is the disclosure that's given to adoptive parents. And it will say on there, if you look at the bottom on the second page, it says that they received the child study. It also says that they received all of these other documents. 9 out of 10 times, my families have not received any of that information. And so when I get that first inquiry call, before someone has selected the attorney to finalize, I tell them, do not sign anything until you show it to me. Tell the agency, tell the CBC, tell the dependency worker, tell the adoption specialist that you now have an attorney and they can run it by me and call me. The importance of that cannot be understated, because what happens frequently is if you take on a case to finalize the adoption, you are taking on a massive amount of liability if you do not check all of these situations and eligibilities that the child should have put in place. Because the most important takeaway that you can take away from this proceeding and this training is that all of these things have to be in line and figured out prior to the signing of the adoption assistance agreement and prior to the signing and finalization of the adoption. Because even if the child has needs now, you have to also predict and project what the child's future needs are, even if they are not receiving those services right now. So let's say, go ahead to the next slide. This is, I'll go to that later, but I'll tell you really quickly. Everyone's entitled to a cost of living enhancement, but you wouldn't know it. So you need to pay attention to the memos that come out from DCF and the cost of living allowances that happen every year. And you have to make a specific request that once you've finalized, if there's a cost of living increase, that you contact your post-adoption specialist in the circuit where you finalize the adoption and ask for the increase. You will not get it if you don't ask for it. Go to the next slide, please. This is just a worksheet that I bootstrapped from another agency and took off their information that helps you look and see what type of needs the child might have as a checklist as you're going through things as you work up the file. You can go to the next list. The next slide. That's still part of the first one. Go ahead. This is the end-all be-all form that your family is going to be asked to sign. There's a lot of small print at the top. And basically, that's explaining where the money is coming from, more or less. And we're not going to get into that now, but certain children qualify for federal funds, certain for state funds, and they don't always mix. The program is administered by DCF, but it is a federal-state collaboration. And some children are considered Title IV-E eligible, some are not, and that can have implications in some of the benefits. Yes, we will send slides, and I have other things that I will send you as well. I'm trying to race through the subsidy stuff so that I can get through to the foreign children questions. But let's go through to the next slide. This is a copy of a denial letter. Someone requested an enhanced subsidy and it was denied. And this is what you get back if you're lucky from DCF. DCF does not have a time frame within which they need to act on your request for an enhanced subsidy. And the only way to trigger DCF to respond, in my understanding, is to request a hearing. If you request a hearing, DCF has 15 days within which they have to respond to you regarding your request for a hearing. And that's the way to push the envelope, because you can make a request for an enhanced subsidy and it can just sit there. This is the denial letter. You can go ahead to the next slide. This is going to tell you your information about how to take an appeal. And that is done under Chapter 120 of the Administrative Procedures Act in Florida. So of the two statutes, there's the enabling legislation for subsidies, and there's Chapter 120, and most of the rest is going to be unwritten, unknown policies and ways of operating that you may not know about. And that's why we've got Indiana Jones trying to figure out what's going on. Okay, go on to the next slide. Okay, now I'm going to go on to some tips and traps, okay? And I apologize for going so quickly. This first slide right here is a sample of a very simple form that I have my families fill out. And this is an affidavit regarding disclosure and waiver of adoption subsidy. If you are representing a family and they are finalizing and they are not going for an enhanced subsidy or a maintenance subsidy, or if they are, you need to cover yourself to make sure that it wasn't you who left on the table benefits that this family or child should have. So when you take on a case and you're given the $1,000 in reimbursement from the CBC or the state, however it's done, you have to know that you might be signing up for a lot more liability than what you anticipated. So I make sure that when I take a client on to finalize for them, I will do the finalization. I will file the papers. I will attend one hearing. I will help them get the birth certificates and the final judgments. But if I have to do work related to subsidies, they have to pay me by the hour. Doing just the finalization for the $1,000 that gets reimbursed to you, and if it's in Broward County, you're taking filing fees out of that. It's one thing to be doing pro bono work and assisting, and we all have a heart. That's why we're in the adoption world. But to take on the subsidy aspect of it without protecting yourself is a major no-no. So this is just a sample. They can be more creative, but I always make sure I have one on file so that my clients are very clear that if they would like to engage me for services beyond a strict finalization, they know that they will have to pay me for it and that it's not included in the $1,000 of non-reimbursable expenses. Go on to the next slide. Okay. All right, go back. All right, so now I'm going to go through my tips and my traps regarding finalization and subsidies. So one of the things that I'm going to tell you is that you have to know the law. You have to know the law and learn the law. And you have to assume, you can go back to the tips and traps slide so nobody's getting ahead of themselves. Okay, thank you. You have to not assume that the person or people that you're working with know the law. It is your job to know it and educate them and correct them if necessary. It's also really, really important that you know the law because you may wish to adapt your case to fit the law. For example, the example Christine had about when are you going to finalize for a child that is eligible for extended maintenance subsidies because they reach age 14. I have a case that I just worked on where a family came to me. The children had been in a long-term permanent guardianship set up through the department. I got permission from the department to reopen the case, dispo the kids back into the care of DCF, so that then when the grandmother could adopt both children, she would be able to receive for those children the subsidies, the tuition, and all of the other benefits that those children should have gotten. If I had just taken that case and gone the easy way, I could have just moved to do a finalization and an adoption because in this time the mother was willing to consent. I could have taken her consents and I could have finalized in family law and in Chapter 63, and I would have done a huge disservice for the family. Another thing that you want to be really well aware of is that maintenance and adoption subsidies, they aren't only available for children who are adopted from the department. You can have a private placement where, but for the private placement, that child would end up in state care. And therefore, you can get a licensed child placing agency to file for benefits and subsidies on behalf of that child. You can't do it as an attorney on your own, generally. You need to have a child placing agency do it. Now, one of the benefits from that is that you retain some of the subsidy and post-adoption benefits, but not all of them, like you don't get tuition. I'm going to go quickly through this. The other important thing is that you make sure that whatever the medical needs are the child are, that they are all established before placement, so that on your adoption assistance agreement, you fill in what diagnoses and what services that child might need in the future, even if they're not getting it now. Because if you go back later after you finalized and you haven't accounted for needs that were projected and known at the time, you have just sold out the child and the family to be able to obtain those services. What happens is if you do go back and you do appeal and you do have the ability to go back, the retroactivity of those payments is going to be triggered by when you asked for them, not by when the child was placed with you or when those needs were discovered. Medical evaluations have to be current within a year, so you want to make sure that those are up to date. You want to make sure that your family gets full disclosure of the documents on that disclosure sheet before they sign anything. And trust me, you are going to get flack sometimes. I have had cases where a child has very, very special needs, and I haven't even had to ask for an enhanced subsidy. I've been told by the workers and by the adoption specialist, and in conjunction with the GAL and the DCF employees and workers, and everyone works together to make sure what's done is done right by this child. So even though I come from the private sector, it's really important that everyone understand where their position starts, where it ends, and how to work collaboratively. Don't assume that somebody did something to screw you over, to screw the client over, and excuse my vernacular, but that's the only words I can use to describe it. Everyone's sort of in their lane. Like the conversation with Christine that I had about Chapter 63 requires that you have a PFR filed when you do the finalization, even though it makes no sense. I have this debate all the time with DCF where they get a no father order, but I don't have a termination of an unknown father's rights. There are distinguishes and differences that happen when the case transition between one and the other. And yes, I see the comment, the putative father registry. One of the other things that's really, really important so that your subsidy doesn't get denied is that you document in your file that this child, attempts were made to place this child without getting a subsidy. And the reason that that has to be documented in the file is because one of the benefits that we didn't really go over is the federal adoption tax credit. And if you have a finalization and a subsidy packet that doesn't show that an individualized determination was made to show that that child has a special need, not just that they categorically meet a special need based on what 409 says, but has something that was specifically figured out related to this child, the family might later on down the line find out that they have no access to the federal tax credit, which is substantial. Other issues that you want to look at are the transportability of benefits, whether or not the adoptive parents are in one state and the child is in another state, if the child moves from state to state, if a adoption disrupts, what happens to those benefits and how does a new family get them? You also want to look at issues of divorce. You want to look at what is left in the master trust for the child. Make sure, like Christine said, that you're getting the benefits. If the child has been in daycare and they're going to lose their daycare benefits, even though they're getting a subsidy, you want to see if you can get a referral, because if the referral lasts for 6 months, you can maybe extend the daycare benefits. And if you're not a lawyer, get a lawyer. I disavow any reference that Robin made at the beginning of this, that I am in any way, shape, or form an expert on all of this. And that's why I agreed to do this, because this is meant for issue spotting. This is to make the light bulb go off in your head that, wait a minute, I have an issue here. I either need to call someone or a bunch of someone's. I need to pull out the statutes. I need to pull out the regs. I need to pull out the operating procedures, and I need to ask a lot of questions. And trust me when I tell you this, I have lots of colleagues who are watching right now who, to me, are more expert than I am. Amy Janae, Alan Michelle, Maria Bates, others that I'm not even naming. And every time we read these things, we discover something new that we hadn't realized was in it. So the only bad question, stupid question, is a question that you didn't ask. So I would expect that you be lost, confused, unsure, And if you're feeling that way, then you are doing the right thing for the child and for the family, because you're going to dig and dig and dig until you can dig no more before you allow them to sign the adoption assistance agreement and before you finalize the adoption. I have gone to many, many, many status conferences in front of judges and general masters where I say point blank, yes, this is an adoption status conference. No, we're not ready to finalize. Yes, I have the packet. And no, I won't file my petition because we haven't worked out the details of the subsidy. Also, for example, one of the things that's really difficult, and you have to know the child's history and medical history, is you don't know before age 2 or 3 or 4 whether or not the child can even be diagnosed with some of the issues that they're going to face later. So if they sign the adoption assistance agreement with a lurking autism or disability in there, and you didn't put it on there, and then they later need those services, you're going to be shut out of them if you did not list those as possible services that might be needed in the future. Okay, I'm going to buzz right through all of this to get to the part that I'm not an expert on, but I do know a little bit more about. So one of the issues in subsidy, and it's a perfect segue, is that there are citizenship issues. And generally, if you're not a US citizen or have qualified non-citizenship status, that means that maybe you have an approved SIJS, maybe you are here as an asylee, or you were granted entrance into the country in some way that gives you non-citizen, but you have the qualified status, then you're not eligible for these benefits. You can look those issues up in 39.5075. The problem with 39.5075, dealing with special juvenile immigrant visa status, is that there have been changes that keep happening that make that a less viable option for children and give them less protection. So if you have a child, and the statute provides that DCF shall provide services to allow the child to obtain SIJS status if applicable. But what it doesn't allow is for you to fix this issue of a child who is a non-citizen being adopted. Because if you see by my slide right there, adoption does not equal citizenship. It creates parentage, and that's it. You can go to the next slide. So you think you are finalizing an adoption of a foreign-born child, and you're doing it in the United States, and you're doing it in Florida, and so you think that that is a domestic adoption. Well, I got news for you. If the child's country of habitual residence, meaning if the child is from a country that is a Hague Convention country, more likely than not, that child is still considered to be habitually resident in the country of origin. And so if you do an adoption between U.S. adoptive parents who are U.S. citizens of a child from a convention country, you've technically branched over the line of possibly having been involved in an intercountry adoption. There is a way to fix this, and it's generally better to be done prior to the finalization of the adoption, but you might not have the opportunity. Go on to the next slide. The world of adoptions for foreign children, there are 3 pathways. Either you do a Hague Convention adoption where the child starts out in the country of origin, the adoption happens there, the child comes to the United States, and by virtue of those statutes becomes a citizen by operation of law. That's for a Hague Convention country. All the other countries where the child gets adopted or a guardianship abroad and then comes here and perfects their citizenship are non-Hague orphan cases. And then if you look at the last category of cases, which are the immediate relative adoptions, that's what you're going to end up doing when you finalize an adoption of a child who's foreign born, who's being adopted in Florida. And to adopt those children, you have to write to and get citizenship for them through that adoption. You're going to have to write to the central authority of that child's country of habitual residence and get certain fact findings that are put in the final judgment of adoption so that you can then later use that final judgment of adoption to then apply for immigration benefits for that child if the child does not have another pathway or another timely pathway for citizenship. Go ahead and go to the next slide. That's just go to the next one. This is the wording of the statute, and this is going to tell you the information regarding those key words on habitually resident. I could speak for 3 hours on that, but we won't. I have 3 minutes left. What's the next slide? All right, I'm going to go back to this again. A prudent question is one half of wisdom. And so I know I threw a lot at you all at once, and part of that is because it's a hefty topic, and part of that is because we have a shortage of time, and I want to respect your time. I am willing to field your questions if you send them to Jorge and put them in the chat. There is a way, if you have a foreign-born child, to fix their immigration status through an adoption. I'm going to speak to Rob, and maybe we'll do a whole other session on that one because it could take up the whole time. And as for the forms that we have and the tips and the traps, please feel free to reach out. And I apologize for being so quick. And I hope you got something out of it, which is just enough to know that you've got another question to ask and another person to call and another document to read. Thanks, everyone.
Thank you,
All
Susan.
right.
You did an amazing job with the squished amount of time. We really appreciate
My pleasure.
that.
All right, so I dropped the CLE code in the chat. I'm gonna read it out loud just in case. It's 2606999 and S in Nancy. If any of you need the certificate, feel free to email me. The same thing goes for any other remaining questions that you may have. Feel free to email me and I'll make sure to connect you with Susan and Christine. I also included the link for what I'm calling the series page. You can find information about recent webinars and upcoming webinars for this series. The next webinar will be, I'm blanking on the date right now. It's in August and it's going to be led by Robin on independent living benefits. So thank you all for joining. Thank you so much to both of our speakers, Christine and Susan, because even though it was a lot of information, it was really informative. It's one of those topics that is extremely complicated. So we really appreciate you putting all these materials together and condensing this presentation for everybody. So any final words, Robin, before we wrap up?
Nope, just
I
thanks,
think
everyone.
all right. Thank you, everybody. See you at the next one.
Bye-bye.
Thank you.